And hello and welcome to the Disability Law Show. I'm John Scholes. He is Sivan Tumarkin. We talk about disability law and everything under that rather wide umbrella. If you want to contact right away, by the way, as we go through the show, it is 1-855-821-5900 and help@disabilityrights.ca. Sivan, lots of stuff to get through today, including the topic of three things you should do if your long-term disability insurance company says that you must try to go back to work, but you are not ready yet. So we're going to cover that here in just a little bit. And being forced back to work basically is what we're talking about. So week that was is how we start every show. What do you got for me today, pal?
John, it's been another very, very busy week, and these are excellent topics. We're going to cover all of them. Let me tell you about an interesting call that I received this week from a lady in Mississauga in Ontario. This lady is 42 years old. She has a 3-year-old girl that is severely disabled. And this lady is a single mother. She works 2 jobs, and she finally had a nervous breakdown. In fact, I was contacted by her, but behind her I could hear someone else, and it ended up being that it was her sister that was helping her and told her to call us. So I was speaking with her, and what I understood to have happened is that she was on short-term disability, and when she applied for long-term disability with her insurance company, they denied her claim. And get this, on the basis of insufficient medical documentation. But within that letter of denial, they stated that because she can take care of her 3-year-old disabled daughter,
right,
they believe she should be able to do her office job. Right. How ludicrous is that argument? So you just imagine how much that aggravated her anxiety, her frustration, and she pretty much almost gave up until her sister told her to call us. Now, keep in mind, she has a psychiatrist that has been prescribing medication. She has a family doctor. They're very, very supportive. And they've said this lady needs to be off work. She's unable to go to work at this point. Despite that, the insurance company denied her claim with that single letter. And she essentially almost gave up. And so when she spoke with me and told me about that, and I saw, the denial letter, and I saw some of the reports from the family doctor and the psychiatrist, I'll tell you, John, first of all, I was livid that this could happen to someone like that who's dealing with a very serious issue at home with her child, and just frankly that it's unfair. And under the LTD policy, they can't do that. You see, all you have to show in order to qualify for long-term disability is that you cannot do your own occupation, or if you're beyond that 2-year mark, that you can't do any occupation for which you're suited for by training, education, or experience. If you have doctors or treatment providers that write a letter, they write letters, detailed letters. We're not talking about a paper napkin, just a note, but something more substantive. And they say that this person is unable to work because of X, Y, and Z. The insurance company should then approve you for disability, and they should be paying you disability. And so what is the option that I gave her? Very simple. Let's start a legal claim, because I can almost guarantee you and her and the audience that as soon as I start that legal claim for her, as soon as internally within the insurance company that claim goes to that department that deals with legal claims and there is a defense lawyer that looks at this, that person will likely pick up the phone, call me, and try to solve the case, try to resolve the case. Because they know that if this ever went before a judge, they will be dead in the water. And this is something that is really important to understand, that insurance companies are betting on you as an individual claimant to walk away from money that is owed to you. You think that if they deny your claim, that's some kind of an official thing, that, their word is the word of God, and, you may want to appeal it to them. Look, insurance companies are in the business of making money. This was a prime example. I will help this lady. My team will help this lady. I promised her that I will help her. And I'm telling you, it's not going to take a long time to resolve. She's going to pay absolutely nothing until the insurance company pays her what she's owed. It's that simple. We will resolve that case.
Because we're talking about it here, does that make it an outlandish case, a standout case? Yep. Or is this very common with insurance companies to cut people off and deny?
Well, so there are many, many reasons for why insurance companies deny LTD claims. Is this an outlier? It's difficult to say, because every day, not a day passes when I don't get an email or a letter or a phone call from someone where I think, my God, I've never seen this before. This is an outlier as well, because some of the stuff that I see is so ridiculous for insurance companies to do this to people. And so, look, at the end of the day, the legal principles are the same. The insurance company cannot deny your claim when you are legitimately disabled, when you know you can't work, when your doctors confirm that you can't work. They cannot deny you the money that's owed to you. They collected premiums for that. They have to pay you under the policy. Again, they're just betting that you will walk away from that money, that you'll simply give up, think that it's impossible to go against them. It's the furthest thing from the truth.
DisabilityRights.ca is the website. You want to catch past shows of this nature or find out where you can catch our radio show, which we've been doing for years. You can go there and search it out. help@disabilityrights.ca is the email address. What else you got going on?
So, one of the things I want to talk about is this new tool that we launched recently with my partner, Lior Samfiru. He's an employment lawyer, so our firm deals not only with disability cases, but with employment law.
They're intertwined.
They're intertwined, absolutely. Many people who are on disability also have issues with their employers, and vice versa. People who are employed then want to go on disability and they find that there are issues. So we help absolutely both. And that's a very unique thing that we do at our firm. In many firms, you'll see disability lawyers or employment lawyers. In our firm, they're together. And so this pocket employment lawyer, which I'm sure you'll give the audience some information, it allows people to anonymously and quickly get answers to pressing questions about their employment rights, whether you've been dismissed from your job or whether you're being harassed or whether you've been constructively
Human rights violations.
Human rights.
Stuff
You
like
can go in and within minutes, literally, get answers to your questions. And if you're disabled, that pocket employment lawyer also has that disability component. Go to the bottom, you will see there are questions about your disability. Again, maybe you don't want to call us, maybe you don't want to email us for whatever reason. You want to get this information, forget about Google. You're going to get the wrong answers. Go to Pocket Employment Lawyer. Is it Pocket? It's .ca.
Yep,
PocketEmploymentLawyer.ca. Phenomenal tool, just created, and it's been used thousands of times already.
Yeah, you bet. Again, it's free of charge. You can't pay for it if you wanted to. PocketEmploymentLawyer.ca. And if you want to walk away anonymous, you could do so. Just use the information that you mentioned, Sivan. Or there's a contact button at the top right, a little yellow button that says contact us, and you can do that as well. Email address, as mentioned, help@disabilityrights.ca. I want to get to the first one of the day. This one, Sivan, comes from our pal Carolyn. She says, my son was injured during a hockey game 2 years ago. He worked as a trades worker at the time, and because of his injuries, he went on EI and then on long-term disability. Now the insurance company says that he has to try to go back to work despite the fact that he can't, and his doctors agree that he's not ready. I've talked to his union, and they said that they don't deal with long-term disability. I'm worried about what will happen if they stop his payments. Would they tell him in advance that they're going to stop? Should he speak with someone higher at the insurance company?
Excellent question. So there's a few issues that we have to flesh out here. Number one, first of all, we're dealing with a claim where the doctors are confirming that Carolyn's son is disabled.
Right.
So this goes back to what I said at the beginning. If your doctors say that you are disabled, you should qualify for LTD. In this case, he's getting the LTD, but he's being told that he has to try to go back to work. We're going to talk about that later on in the show in more substance. Ultimately, the question of whether or not you need to go back to work or not is a question for you and your doctors, not the insurance company. They cannot force you physically to go back to work.
Or your employer.
Or your employer, exactly. They cannot force you, and they shouldn't force you, but they try to force you. They try to coerce you, and the way they do that is by saying, we're going to cut you off. So to answer Carolyn's questions, generally when insurance companies cut you off LTD, they give you a heads up. And this is very important to understand. Because, let's say today is July 1st. Okay. They're not going to tell you that they cut you off last week. They're going to tell you they're going to cut you off in a month or 3 months. I've seen it as far as a year down the road. The reason why that's important is because as soon as they tell you they're cutting you off, you should immediately contact us because we can do something about that right now. Within the legal terminology world, it's called anticipatory breach. We will take the position that by them telling you that they're going to cut you off, despite the fact that you're still disabled, and despite the fact that your doctors say that you're still disabled, they have breached their obligations under the policy, which means we can act now. If you wait, and you simply wait for that cutoff date, or you try to appeal that decision internally within the insurance company, they're going to drag out the process. You're going to get to that target date, that deadline. It's like a cliff. You're going to fall over it because you're going to find out very quickly that once you get to that date, beyond that, you're not getting paid. So very, very important. Now, should he speak with someone higher up at the company? Doesn't matter. Doesn't matter. They've made their decision. Insurance companies are these huge bureaucratic entities. And at the end of the day, once they make a decision to cut you off, it's almost impossible to change their mind. So when we get involved, we don't look at changing their mind. We look at changing the dynamic. We look at changing the playing field, because up until you have us on your side, it's essentially an uphill battle. You're essentially a David and Goliath situation, right? Once we get involved and we instigate that legal process, like I said, internally within the insurance company, everything changes. There is a dynamic shift. Your claim is no longer being held by the same adjuster that denied the claim or cut you off. Now it moves to a new department, a new adjuster whose job it is to resolve the case. They now have a defense lawyer. And what happens when there's a defense lawyer? The insurance company now bleeds money. Now they have to start spending money on legal fees. They don't like to do that, which is why at that point, they shift their thinking into how can we solve this issue? How can we resolve the case? And that's where, we get our advantage, and that's how we resolve these claims for individuals like Carolyn's son.
It's interesting the fact that you said, once you get the warning that is coming down the pike, whether it's a month, 6 months, or a year, it's almost counterintuitive to say, call you now and do something about it now. The natural thinking is like, well, you know what, I'm going to take advantage of the 7 months I have left at least. Why would I give that up and call you now? But that's not the way you want to attack it. You want to get on top of it.
Well, let me give you an analogy. You're driving on a highway and you're hearing on the news that 3 kilometers down on the road, there is a big accident. Are you going to wait until you get there, till you get stuck, or are you going to try and find an alternative route, to get out? That's essentially what I'm saying. You are being told not only that there is an accident, but that you are the accident. That you're going to get hurt within 3 months, 5 months, whatever. And, I had a case, I remember, about a year and a half ago, this individual in Ottawa that was told a year in advance that he would be cut off. And there was zero basis for them to take that position. We started that legal claim within weeks of him contacting me. And, John, we resolved his case before that 1 year period. And so the benefit was that he was never without money because they continued paying him for that 1 year. They said they would. And at the same time, we were able to resolve his claim.
Nice.
And it's crucial, because imagine if he waited that 1 year only to find out that at that point he's not getting paid anymore. Then we get involved. It takes us, let's say, 6 months to resolve the case. For that 6-month period, he has no money coming in. How does he pay for the mortgage? What do you do with the kids, with the expenses that come in? That's why I'm saying you have to be proactive. And the thing is this. There's a lot of people who are listening, who are watching us, John. They themselves are not dealing with an LTD insurer, but they may know someone. They may have a friend, a family member, a colleague. Please give them this information. It's just absolutely crucial to have this information, because insurance companies operate within this world where they give you either misinformation or they don't give you information. And so all you have are assumptions. And the biggest assumption out there is that you can't do anything when you are denied or cut off LTD. And that is an incorrect assumption.
All right, coming up here after we take a short break, your insurance company says you have to go back to work, but you're not ready. 3 things you must do if that happens to you. 1-855-821-5900. Help at disabilityrights.ca. Disability Law Show continues. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
All right, and welcome back. The Disability Law Show. Your host, John Scholes, along with Sivan Tumarkin. We always take a topic and we get down into the nitty-gritty and dissect it and give you some answers. You want to reach out anytime, by the way, 1-855-821-5900, help at disabilityrights.ca, or just simply disabilityrights.ca. You want to catch old shows or find out where you can catch the radio show, that is the place to go. So here we go. Without any further ado, my friend, 3 things you should do if your LTD disability insurance company says you must try to go back to work, but you are not ready. Number one is this: get letters from your doctors explaining why you're not ready to go back, and send those to your adjuster, right?
Yeah, I can't stress how important that is. You have to have your doctor's support. And, you know, John, I was in our Vancouver office last week. We have an amazing team of lawyers there. And me and an associate of mine met with this individual there who exactly is in this situation, who you know, is getting pressure from the insurance company, and they want him to try and go back to work. It's called a return to work program or a gradual return to work program. And they've even set him up with an individual that helps people try to get back to work. And this person is crying as he's telling us that he's simply unable to. I mean, he was hardly able to come to the office. I mean, we asked him if he wanted to come to the office. We don't, you know, people don't have to. We do it by phone oftentimes. But he came with his wife, and he was breaking down. And I asked him, I said, when is the last time you went to your family doctor? And, you know, he has a physiatrist and a psychiatrist. These are two specialties that we often see reports from. And he said, you know, the last time was 5 months ago. And I said, well, I think it's time to get updates from those individuals because he sees them every so often. I said, you have to understand that when your doctors are providing letters, and we're not talking about 10-page reports. It can be half a page, it can be 2 paragraphs. It just has to be a little, there has to be substance to it. It doesn't have to be a novel. But there has to be more than just this person is disabled. So if you have those letters, if you can get those are your shield. Give those to your adjuster. Make sure that the adjuster has those in conjunction with you explaining to your adjuster that you are not ready to go back to work. That is a very, very powerful tool to thwart them forcing you or trying to force you to go back to work. Your doctors are your shield. Remember that.
In your experience, what is an accurate timeline? Every couple months be in touch with your doctor, or every 3-4 months? I guess
it really
depends
is
on
case
the
by
severity
case.
of your case, right?
I have some individuals who have plateaued from a physical standpoint after an injury, and they don't go to their orthopedic surgeon anymore. There's no point, or you know, there's no. I mean, they go to the family doctor because things come up, so they'll go every month or so. Sometimes, if you're dealing with a mental health issue, you may have appointments once a week, twice a week with your psychologist or whoever it is you're dealing with. It really does depend. But at the end of the day, if you're at a critical juncture where the insurance company is telling you you have to try to go back to work, and you know you can't, and your doctors say that you can't, get those letters from your doctors, current letters. Go today, get those, give them to the insurance company. In most instances, that will make them back away. Okay. If they don't back away, you've now set them up. In the event they cut you off, we can go after them full force because there's absolutely no way they would have a leg to stand on to contradict your doctors who are the ones treating you.
Yep, your insurance company is saying you got to go back to work, you're not ready. The second thing you should do is this: email your adjuster and explain why you don't feel that you're ready to go back to work. Have a record.
Have a record. Have an absolute record. And you know, this is important because this goes to a broader point that James, who's often on the show, expresses, which is you need to make sure that you have a documentary record with the insurance company. But it's really important that when you are being told that you have to go back to work and you've gotten those letters from the doctor, that you provide those letters, I would say in an email, and within that email, document how it is that you are feeling and why it is that you feel that you can't go back to work. Be descriptive, because guess what? That email will make its way into the adjuster's file. And again, you are doing 2 things here. This is a strategy, 2 things. Number one, you're putting it in writing to them so that they have to now deal with it. They can't ignore it. It's not something you said on the phone that they can simply say was never said. That's number one. And number 2, you are papering the file. You are putting and creating a record that we can then look at 6 months down the road, a year down the road. Whenever it happens that we have to get involved, we can look back and you know, those little emails that you have sent are like landmines for the insurance company. Number 2 is explaining to your adjuster why you can't go back. Number 3 kind of expands on it, dovetails from it, and says document all communications with the adjuster. I know James has often said if it's a phone call, you simply say, you know, just hang on for a second. I want to grab a pen and paper. I'm going to take some notes as we chat, because there's got to be a record of it. Absolutely, absolutely. And so the idea behind this is, again, it relates to the second point, which is that you want to make sure you document everything. We live in an age where you have facts and then you have alternate facts, right? It really depends on who you ask. There's different vantage points. And I see it all the time when the insurance company, when they produce their files, once we go after them legally, they produce their files and they'll say, I called Joseph on this and this date, and I asked Joseph, how are you doing? And Joseph said, I'm doing okay, I'm feeling good today. And then suddenly they rely on that, they seize on that, they cherry pick that particular phrase, and then they'll use a few of those over the course of a few weeks or a few months or even a few years, and they'll say, well, it seems like this person is improving.
Says he's doing okay.
Yeah, even though it's nonsense.
Good.
So you make sure that every conversation you have with the adjuster, you immediately after email the adjuster a record of that conversation. I'm not saying that you record and then do a transcript. I'm saying, this is what you told me, this is what I relate to you.
And send confirmation.
And send confirmation. And chances are the adjuster won't even reply, which is actually a good thing, because then it's uncontradicted. And frankly, if they reply back, let's see what they reply back.
Sure.
Right? They're not going to think that you are in fact building a record. So do that, because it's extremely powerful. And in cases, I met with a lady a few weeks ago, again in Vancouver, who is a legal assistant, and she's off on disability right now. I have never seen someone keep such great records and email correspondence with adjusters as I've seen her do. And I told her that. And I'll tell you, John, if they cut her off, they are in for a world of trouble, because she documented everything by email. Everything. And you can see how they're not responding to her, which, as far as I'm concerned, means that they are confirming it. They're agreeing. So very, very powerful. Document all your conversations with the adjuster.
All right, next question we have up for you and for you as well, Sivan, is this. Can you be cut off of your LTD if you've been denied CPP? We'll tackle that after a short break. 1-855-821-5900 and help@disabilityrights.ca is the email address. Lots more Disability Law Show is on the way. Stand by.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to the Disability Law Show. You'll want to reach out, 1-855-821-5900, and disabilityrights.ca is the email address. MyDisabilityQuestions.com, that is another resource for you to ask your questions. James, Sivan, they answer the questions quite regularly. Drop-down menu, there's a high probability that if you've asked a question or you're thinking about it, it may have been asked in the past. You can search through the database and there'll be some answers there for you before you even have to type in. But if you want to, MyDisabilityQuestions.com. This comes from that. Sanjeev writes, Sivan says, I applied for CPP Disability after being on long-term for a year and a half. I just got the denial letter from CPP, and I'm planning on challenging the denial with my doctors, who are very supportive of me. I talked to my LTD adjuster, who said that because I was denied CPP Disability, I will likely be cut off soon. I don't understand why. Can I challenge the LTD insurer? He said that the letter will be coming soon that will give me the cutoff date and how to appeal. We love that word. Should I call you when I get that letter?
No, it's a good thing that you called or that you emailed us right now, because you don't actually have to wait for the letter to come in the mail. I mean, we want to see the letter, obviously. But let me tackle this and dispel some myths. When you are on long-term disability, your insurance company may or may not ask you or tell you to apply for CPP disability. And they do that for a very simple reason. If you get CPP disability, you get approved by the government for disability.
Right.
The insurance company gets a credit for that amount. So if they're paying you $3,000 a month and you get $1,000 from CPP disability, you don't get 1 + 3 = 4. You get 3. It's just that you get 1 from here and 2 from here. Exactly. So that's why they have an interest in getting you to apply. Now, the test for getting CPP disability is different than long-term disability. The test for CPP disability is severe and prolonged. You have to have a severe and prolonged disability. Again, you have to have your doctors confirm and provide in the application information that supports that.
Arguably tougher.
Arguably tougher, but still different. Yeah, sure. Yep. But the thing is this, this individual here writes, Sanjeev, he writes, he was denied for CPP disability, and the adjuster tells him that as a result, he's likely going to get cut off soon LTD. Those are two separate things, absolutely separate. Can the LTD insurer cut him off because he was denied CPP disability? They can. Should they? No. Would they have a legal basis for cutting him off LTD because he was rejected by CPP disability? Absolutely not. Absolutely not. In fact, I've seen cases where people have been on LTD, they also get CPP disability, and yet they get cut off LTD despite being on CPP disability. So remember, insurance companies are there to make money, and they will use any reason, any excuse to cut you off. And so the answer for Sanjeev here is that there's no reason for the insurance company to cut him off so long as his doctors continue to say in writing that he's disabled from working in his occupation or any occupation, depending where he is on the test. But he should not wait for that letter. He should have made contact, which he did by way of the email. And you know, one thing I want to address is this. The adjuster told him that in that letter, he's going to have instructions or information on how to appeal that decision.
Use the A word. We don't like that one.
The A word, yes. Yeah. We've covered this countless times. Do not appeal these LTD denials. CPP disability is different. You want to appeal that? Go ahead. Try that. But an appeal on an LTD claim will most likely lead you nowhere. And again, every single day people contact me, not only because they've been denied long-term disability, but because they've been denied the appeal and then the second appeal and sometimes the third and fourth appeals. And in the meantime, you have no money coming in. Again, you can't pay for your expenses and you know you're disabled. Your doctors get frustrated because they don't know what the insurance company wants. Do not appeal these decisions. We start a legal claim. It's a much more powerful tool against the insurance companies because now we take the power away from them. Right. They know that if they don't come to the table to settle the case, to pay what the person is owed, they know that they will get hammered by a judge. That's the reason why when we get involved, we resolve these cases. Not because, you know, we have a superhuman touch or we're magicians. It's because we understand the process and they know that we know the process. So you have to understand that. So Sanjeev did exactly the right thing here, and he's correctly confused. You know, why is he being cut off LTD or potentially cut off if he was cut off by CPP disability, or sorry, denied CPP disability? There is a correlation, but you can't. It's
a bit of a stretch.
It's a stretch. You can't. You can't use a denial of CPP to say that we're going to cut you off LTD. It's a separate claim. Yeah.
And the whole appeal thing, as you mentioned, there is a time limit of 2 years once you've been cut off and you start sending those appeals. That does not reset the clock. Right?
Yeah, you have to be very, very careful. If you've been denied the LTD and then you try the whole appeal process, the case law generally says that you have 2 years from the date you were first denied your LTD or cut off to start that legal claim against the insurance company.
Right.
There is some maneuverability around that. You know, can you get around that if you appeal and they deny you again? Don't take that risk. Don't take that chance. I've seen cases where people come to me after seeing the show 3 years after, 4 years after. We can't do anything. The insurance company is laughing with your money in their pockets. You don't want to do that. Again, as soon as you are denied LTD or as soon as you're cut off or told you will be cut off, you should be coming to us. We will tell you what you need to know. You don't have to proceed with the options we outline, but at least you'll be informed. You'll have the information you need. It's absolutely crucial.
Last 30 seconds, man. Final thoughts for the day.
You know, the final thoughts, and it's really, really important. I want to make sure that people understand that you have a lot more power than you think with insurance companies. It's smoke and mirrors oftentimes when they cut you, your LTD, when they deny your LTD, and your doctors will get frustrated. But, you know, there are options out there. There are options. Don't give up. Please don't give up without at least listening to what the options are. Let us help you. We will help you. We've helped thousands of people like you.
It's a matter of reaching out. It's really quite simple. 1-855-821-5900 is the phone number. help@disabilityrights.ca is the email. You want to send one along. We'll try to get it on a future show. And simply disabilityrights.ca is the website to catch past shows and find it where you can catch our radio show as well. Catch you again. Disability Law Show. Appreciate you sticking around.